All rise.
Please be seated. The last case on our docket this afternoon is 0722-00065-CV, McCartt and Associates Incorporated, and 79101 Properties versus Charles Ladell Roberts. What says the appellants? Thank you. And what says appellee? Each of you will have 20 minutes to present your arguments, and appellants will have a 5-minute rebuttal.
May it please the court.
Counsel?
Charles Roberts knew that the elevator doors on the freight elevator were dangerous. He knew the danger, but he stuck his hand between those doors as he was closing the doors anyway. And I want to talk about two principal reasons why the judgment against appellants should be reversed. First, there is no evidence that any condition that Roberts' liability expert identified as unreasonably dangerous was a cause of Roberts' injury. There's no evidence that the outcome changed but for any condition. Second, the danger was open and obvious. Roberts' expert, Dennis Olson.
You opened just a minute ago saying you knew that he knew the doors were dangerous. I guess in some ways all doors are dangerous to an extent. Did he know the precise manner in which the doors posed the danger of the specific injury that was posed to him?
Well, he testified that he'd seen the doors before. He knew they were heavy. He testified that they were scary. He testified that that no sane person would stick their hand between those closing doors. That is all that was required in this case, I would submit. And the conditions that the plaintiff, that
was that the closing door testimony you're referring to? The fact that the elevator doors were closing, is that the open and obvious condition that we're talking about, or is there something else that's the open and obvious condition?
That is all there is. That is the open and obvious condition. These doors that he described as scary, that were described as being 200 to 300 pounds, I think, that closed vertically. This was a freight elevator, not an ordinary elevator. And closing doors, the Supreme Court recognized in Kroger versus Elwood that closing doors are an open and obvious condition. So it's objectively open and obvious as a matter of law, and it was known to Mr. Roberts.
Now here, the dangerous condition is not just the doors themselves. The dangerous condition is the missing astragall, right?
Well, the condition that they identified to the doors, I would submit that that's really the remedy for the danger posed by the doors. That is not the condition that needed to be open and obvious. And I think the cases that the plaintiffs relied on for their argument, because what they argue is boiled down to its essence, that this was not open and obvious because the remedy for the condition, the method of making the condition safe, the danger of the doors, the method of making that condition safe was required expert testimony. Well, that would be true in a lot of cases. That would be true in many cases. And I think we can speak to the cases that they cite, that they rely on. The Los Compadres case, which is the plaintiff's principal case that they rely on, that was a distinct set of facts. In that case, that involved a contractor performing work near an electric line. In plaintiffs were told that the electric line was de-energized. They had asked that it be de-energized. And in that case, the condition was the fact that the line was energized. Here, there's no condition. There's nothing about the condition. There's nothing hidden about the danger posed by these closing doors. There's nothing hidden about that. And I think if you look at the cases that the plaintiff relies on, the M.A. Martinson decision and the Shelton case, both of those really relied on distinct, separate conditions. In the M.A. Martinson case, it was the fact that the shoulder on the road would give way. That was a hidden condition. And in the, can't remember, was the Shelton case or the Roy case, but that was a case that involved a chemical plant. And the evaporation pool, the court said, well, the dangerous condition there was the pallet that the plaintiff stepped on that gave way, that the plaintiff did not know that would give way. Here, there's no separate condition. There's no other condition in this case. I think this court, in a opinion that Severin v. A.O. Smith, that this court issued probably about 2 decades ago, I think is a very instructive case. That was an unpublished decision, but it still can, under the current rules, it can be cited and considered. And I just think the facts of that case and the reasoning are analogous here. That involved a case where a lawsuit against an innkeeper or a hotel owner, where a hot tub was filled with scalding water by the plaintiff's friends before the plaintiff stepped into the hot tub, the 2 plaintiffs. They stepped into the hot tub, they were scalded. They presented evidence that the innkeeper should have set the hot water heater at a lower temperature. It was set at 130 degrees. I think they presented some evidence that it should have been set at 115 degrees. This court correctly reasoned that the risk of the scalding water is open and obvious. The plaintiffs had admitted that that scalding water from a tap can burn you. And the court recognized that as a matter of law, people understand that scalding water from a tap can burn you. So that was the condition. The condition was not the fact that the hot water heater was set at 130 degrees. And I think a way of looking at this, I thought about yesterday, a way of looking at this question is to look at it through the lens of a warning, because in every failure to warn case, except for 2 exceptions that are not applicable here, the defendant may discharge its duty by providing a warning. And the warning needs to put the plaintiff in a better position to know. And in this case, there really is no warning that could have been given that would have placed the plaintiff in a position to know.
Your position is it wouldn't have done anything to put a sign in the elevator that said, don't put your arms in between the closing elevator door.
That's correct, because he knew this was dangerous. No sane person would stick your hand between these closing doors, is what he testified to. So there was no warning that would put him in any better position. I'd like to turn to the question of causation. The plaintiff's expert, their liability expert, and it's important to note, he was not a causation expert. They didn't offer him for causation. They objected to an attempted cross-examination and causation issues because that's, quote, what we're not offering this expert for. So he was only a liability expert, and he identified the 3 conditions. The pull strap that he testified was too short and improperly configured. And the record is a little bit ambiguous on this as to what exactly he was talking about, but 2 overlapping members that posed a cutting risk. and the third was the absence of the astragal. And there's no evidence that but for any of those conditions, Mr. Roberts' injury would have not have occurred or would have been any less severe.
In the record, other than during cross-examination of this expert witness, you're claiming he's not an expert on causation. Anything other than that cross-examination objection, is there anything in the record to support that he's not a causation expert?
Well, there is that, and there is also the fact that, and this is more important, the expert did not testify to causation. He did not testify to the fact that but for the astragal, but for any of these things, Roberts would not have been injured. He did not testify to that, and it's their burden. It's their burden to prove causation.
Does he have to testify about that? If we're talking about the strap, for example, does he have to be the one to do that, or can the plaintiff say there was no other way to get the door closed because I couldn't reach the strap, so as a result I had to reach through the door?
Okay, well, the strap, let's talk about that. That is very important. That was the only condition, the only feature that Mr. Roberts would have come into contact with before he closed the door. There is no evidence that he used the strap. He testified he did not remember how he closed the door.
But if the strap was too short, he couldn't have reached it. Could he?
The expert's theory was that the strap should have been longer so that he would have stepped back. But there is no testimony, and this is very important, there's no testimony that the configuration of the strap prevented Roberts from using the strap. And there is no testimony that Roberts used the strap. Roberts did not encounter the strap. There's no evidence of that. So I believe
So your point is whether the strap was too short or inadequate doesn't make a difference because there's no evidence that he tried to use the strap.
It did not come into play. It's irrelevant. The only way it could have prevented the injury is if he used it. He did not use it. There's no evidence of that. So the strap is out. The second one was the overlapping members. And the testimony was that these two rigid members posed a shearing or cutting risk. There is no evidence in the record of a shearing or cutting injury on Mr. Roberts. There's evidence of a crush injury, but that's not a shearing or cutting injury. I think the best that appellees could do in their brief was say, well, it could have happened. Well, that's not, the law is not concerned with what could have happened.
Was there any evidence in the expert's testimony or anyone else, I guess, who took the stand, that the padding or whatever they were talking about putting on the two edges would have prevented the crushing injury from occurring?
No. I was going to turn to that. The astragal, there's no evidence the astragal would have prevented this injury. In fact, an elevator glossary that was in evidence said that the purpose of an astragal is to either prevent or lessen the severity of the injury. And there is no evidence that an astragal would have changed the outcome, that it would have made his crush injury any less or any different. And I believe that the Supreme Court teaches that evidence is required. That was the Southwest Key decision. In that case, the plaintiff claimed that the negligence was in allowing him to play football without a knee brace. It was undisputed that the football game caused the plaintiff's knee injury. But there was no testimony, no evidence that the absence of a knee brace contributed to either cause the injury or made the injury worse. And the Texas Supreme Court, I think that's about 2 decades ago now, said you need that. And that's analogous to this case because, yes, sticking his hand in the doors caused a crush injury. But there's no evidence that astragal would have changed the outcome.
There were two theories, though, if I remember, of liability. That one was the failure to make safe. Did the plaintiff also argue that they didn't warn, that you didn't warn of the risk?
Well, the plaintiff really didn't address failure to warn. And what's important is that, again, in a premises liability case, and this goes to the Kroger decision, a premises liability case, the defendant has a duty, the property owner has a duty to warn or make safe. Warn or make safe. And there's two exceptions that were addressed in Kroger. Neither of them are applicable here. Necessary use and criminal conduct. Neither of those is applicable. And so the duty to warn could be discharged, or the duty could be discharged by providing a warning. And really, there is no warning in this case that could have changed the outcome. There's no warning that could have changed the outcome because Mr. Roberts testified that he knew this was dangerous. He knew not to do it. He did it. He doesn't know how he did it, but he did it. He stuck his hand in the door.
There was some evidence at trial that the elevator didn't meet the code specifications. Does that get us there on making it safe?
No, it doesn't. It doesn't get us to breach of a tort duty. And the reason is that number one, well, first of all, to clarify the record, there was only one citation back in 2008, I think, or there are a few citations for the lack of an answer goal, and I think the last one was more than about a decade before the accident, give or take. But no, it doesn't make a difference because number one, there was no negligence per se alleged, and there is no negligence per se instruction sought in this case. So it's not a negligence per se case, and even if it was, negligence per se does not speak to the duty, does not speak to the premises owner's duty. It speaks to the standard of care once a duty exists. And there was no duty in this case. And returning to the open and obvious point I want to make is that the question number one, the negligence question, conditioned an answer of yes, there was negligence on a finding that that danger was concealed. That was the plaintiff's instruction. The plaintiff drafted it. The plaintiff requested it. The plaintiff did not object to it.
Did you object to it? Did your side object to it during the charge conference?
My side did not. My side did not. And as we all know, the sufficiency of the evidence is measured by the unobjected to charge. And so the jury had to find a concealed hazard. There was no concealed danger. He testified to it. This is a very clear case. Appellants would request the court to reverse the judgment below. And unless there are additional questions, I will yield my time back.
Any further questions?
Just one briefly. You just mentioned, I was following you on the no causation and the open and obvious, but you just mentioned no duty. Can you elaborate on that? I mean, he was an invitee, right?
Well, there's no duty. The law of premises liability law is that there is no duty to warn of or make safe a condition on unsafe condition on property. There's no duty to warn of an open and obvious condition.
With
the
exception of necessary use.
Well, with the exception of necessary use, and again, this is not a necessary use case because the plaintiffs did not plead it and they did not submit it. And that's not the case that was submitted to the jury. It's not the case that the court signed a judgment on, and it's not the case before this court today. But I think there's the legal question of duty and then the requirement of concealed that plaintiff themselves placed in the charge. They put that in the charge. In their brief, they argue that somehow that immunizes them, or that somehow, because we did not object to that being in the charge, that somehow affects the outcome here. It doesn't.
Does the jury finding no negligence on the part of the plaintiff change our analysis at all with respect to him sticking his hand in there?
No, it doesn't, because they're separate questions. The burden is on the plaintiff to prove that my clients were negligent. They didn't. And that's our third point. And I believe it's, if the court reaches it, it is another basis for reversing and remanding the case, is that this is a case where where the finding that Mr. Roberts was not negligent is against the great weight and preponderance of the evidence. And
Is the question about open and obvious risk, is that a question of fact or a question of law?
Well, it is a question of law. It is a question of duty, but the plaintiffs made it. The plaintiffs in this case made it a question of fact because they submitted the question of whether the risk, the danger was concealed in the jury charge. So it is both. And when there's disputed facts that would go to the question of whether a risk, danger is concealed, of course, that can become a fact issue.
If it's a question of fact, then our assessment of whether it's an open and obvious risk, then we've got to say, at least according to your argument, we've got to show that there's no more than a mere scintilla of evidence of the risk.
Well, applying City of Keller, the court needs to take account of the undisputed testimony that the fact finder could not disregard. And
well, City of Keller says we take in all the evidence. We consider all the evidence.
That's right. You consider the court considers all the evidence. And the evidence that conclusively rebuts the existence of a concealed defect is Mr. Roberts' testimony that these doors were scary, they were dangerous, no sane person would stick his hand between those closing doors.
Your time is up. Any further questions? Okay.
Thank you.
You'll have 5 minutes on rebuttal. Ms. Owens.
May it please the court, Mr.
Counsel.
Higgins. The jury's verdict in the court's judgment should be upheld on all bases because there's factually and legally sufficient evidence as to all issues before this court. But before I address any of those three specific issues, it is necessary to properly define the danger. And that is what the Supreme Court has repeatedly told us in taking these premises liability cases. The danger is not looking at a door. The danger is the fact that this door was not code compliant. This door was able to fully compress, and not only fully compress, but overlap, something that the code specifically said it is not allowed to do. Further, it did not have a pull strap. And what is very important to this case is that that pull strap is designed, and expert testimony establishes that those three things, the pull strap and the astragal with a bumper, are designed to prevent the very occurrence, that would be entrapment, and injury, meaning crush and shear, that occurred in this case. Now,
I believe the appellant, though, argued with regard to the causation issue that your expert identified those issues, certainly identified those potential breaches of the standard of care, but that your expert never said, but for those items, this injury would not have occurred.
correct, Your Honor, and that is not something that expert testimony was necessary for. And if you will look through the record, we repeatedly tried to keep this record clean, and we excluded the testimony of their expert Sweat because she intended to come in and tell the jury from the expert stand that this man was the sole proximate cause of his injury. And they were just as capable of making that determination as she was.
With regard to this pull strap, we've talked about this some. That would certainly be, I would think, one way that the plaintiff could have pulled the doors down. At least an argument could be made for that. Was there any evidence that the plaintiff knew of the strap, attempted to use the strap, and was unsuccessful in doing so before he made the decision to put his arm between the closing doors?
Your Honor, he does not recall. So what he knows is that he reached up with one arm and couldn't pull the door down, and so then he used his left arm, and he used his body weight to pull, and somehow his left arm became entrapped in the door.
But none of that testimony deals with the strap, right? It's simply he was pulling on another portion of the door.
Correct, and respectfully, I believe that that argument is misdirected because what they're attempting to do is compare what should have happened on a code-compliant door or what would have happened on a code-compliant door with this door that had a strap that was 6.5 inches above the bottom edge of the door. So rather than having a strap that the eye would see and that was obviously easier to reach, that was required to be 6.5 feet from the ground. This strap was 6.5 inches above, which I believe, again, the jury was just as capable, if not more, than the expert to say that, sure, if that had been in his line of sight and the easiest thing to grab to pull the door, he would have done that. And the strap, in turn, would have fulfilled its intended purpose to pull the body back and down and away from the pinch point and prevent entrapment, which is, again, very important because as humans, we interact with these machines and accidents happen. But as a society, we have decided that there are simple fixes for some of these known hazards. And number one, if you look at actually the defendant's testimony on her expert, she said that these astragals used to be to prevent smoke. And it makes sense. But this 2-inch metal bar that did a great job of preventing smoke entering the chamber created a lot of shear hazard and a lot of injury. And they decided a smarter, better way is to require those owners to remove those shear hazards and place a metal bumper or metal stopper on each edge that would then create a 3/4 inch to 1 inch space to minimize the danger if entrapment does occur. And again, the code and even the glossaries for elevator mechanics take in that underlying purpose, that understanding that this prevents entrapment, prevents crush and shear when entrapment occurs, because we know it's going to when humans interact with machines.
Back to the code compliance, was there testimony that this elevator was not in compliance, or was it in compliance on the date of the accident?
Thank you, Your Honor. I want to make that very clear because there was an inspection report that I have included as a screenshot in the brief from 2005, and it cites the specific astragal violation and the pull strap violation. And then and again in 2007, the astragal is cited again. Now, what's very important aside from those two citations is each year they sent the state of Texas a letter that said, we will fix these deficiencies. And we know that they did not do so. They told the state they would fix it. They were required to fix it. I included in the appendix of the brief the statute and the administrative regulations that require the owners to know of these violations and to fix them. And so, again, I think this regulation is something that, or the code, and of course the regulations, the duty on the owner, is something that cannot be understated. Because if this were an elevator door that were in compliance with that code, I would agree that this is an open and obvious condition, okay? Because the state of Texas has decided that this is as safe as we can make it. And so this is not something that's going to extend to every elevator door in the state of Texas. This extends to owners that don't do what they've been told to do and what they said they would do. And I think it's so important that we're talking about the duty element here. The duty element of open and obvious is a legal question. And so not are we just absolving them from liability, we're telling other owners that they don't have a duty to warn or to make safe. And so when there's a regulation that's brought to their attention, just like in Los Compadres, I do want to be very clear about that. The court requires an analysis of the totality of the circumstances, and that requires a consideration of the statutory and regulatory violations. And that's at 622 Southwest 3D at 789 to 90. So that's not something that we can push to the side. That must be central to this determination. And that brought me to, I made a note about the failure to warn. There was evidence of failure to warn. Many people on the stand were asked whether there was any signs, whether there are any warnings. And I understand that some things are so dangerous that a warning may not fix them, but
Yeah, what would the warning have said?
Well, there are shear hazard signs, and one, the man who trained Charles Roberts was asked about whether he had ever seen a shear hazard sign. And, if you think about machines and meat packing plants where we guard them, or there are known and specific signs for shear hazards. But again, if they had made this safe, there would be no need to warn of a shear hazard because there would be this much space between the doors.
Well, appellant's counsel pointed out that the injury that he received was not a shear or a cutting, but was a crushing.
Your Honor, that is oversimplifying. There was plenty of evidence before the jury for them to make a common sense determination. So specifically, they heard evidence from Mr. Roberts about where his hand was and what it looked like when he saw it, when he opened the door back up and first saw it. But more importantly, they saw the picture of the hand disfigured and distorted before any sort of reduction was attempted at the hospital. They were able to make that determination. And the treating surgeon even looked at the x-rays and described the injuries for them. So again, if this isn't a case where they can use their common sense to determine that a 3/4 inch gap or a pull strap or the removal of that would have lessened his injury or would have completely removed or prevented the occurrence, then there is no case that I could bring before a jury, that I wouldn't need to hire a human factors expert, that I wouldn't need a biomechanical.
What about this pull strap? We talk about the pull strap. What about the pull strap within the context of the failure to warn? My understanding from the other side's argument is, well, there's no evidence that he attempted to use the pull strap. If the warning had been to close the door, pull on the pull strap, would that have been adequate notice on how to close the door?
Of course, I think that would have satisfied some sort of warning, but the real warning is the entrapment and the shear hazard, because so this isn't just like another elevator if he doesn't use the pull strap and gets entrapped. It's this. It's that extra big red flag, Your Honor. And so sure, that would have satisfied a warning, but it would also need to include some sort of shear hazard warning as well.
Was there any evidence that your client didn't know what the pull strap was for, without regard to whether it was too short or inadequate in some way? I guess my point is this. If the strap is there and nobody uses it because they don't know how to use it, that seems to me to be evidence of a concealed defect because they don't know how to get the door closed.
Your Honor, I think you're correct that it's evidence of concealed defect because the purpose of having a strap that hangs within 6.5 feet is so that most people operating the door are able to use it and they see it below the door. So if you look at the picture, it's Exhibit 9, page 28, you can see how far above the bottom of the door it hangs. So when you're already reaching up to get that high to even touch the door to pull it down, people are already looking up, let alone trying to reach up and over. If that answered your question, sir.
Okay.
I would like to address this estoppel issue because I have not addressed it in writing. It was in their reply brief. So we were very clear before trial about this expert, and we filed a written motion with the court. We had hearing a year before the trial. And in the pre-trial hearing, we specifically discussed this. Judge Gleason recalled exactly what was going on with this expert. And counsel for Roberts, I said, and what we excluded as to Ms. Sweat, their expert, is her saying that sticking the hand in the door, allowing it to be entrapped, is the sole proximate cause of the incident. The jury is more than capable of understanding how this hand got caught in the door. We're not excluding the technical aspects of what an expert is here to talk about. And if that's not enough, opposing counsel asked Mr. Olson these very questions about the purpose of the code and the purpose of a pull strap and the purpose of an astrogol. So what I would suggest is this is a backdoor effort to exclude our expert after they didn't preserve that error and bring it before you. But If that is the case, it has been waived.
Was there any causation testimony offered by Olson?
Yes. Well, number one, I think very important to causation is the fact that the purpose behind each of those elements, right? Because a jury can take it there. We're not talking about the case where the man fell off the roof and, there it takes inference upon inference. We're talking about this very thing is required to prevent this very occurrence and this very injury. But specifically, they talked about scissors repeatedly and have tried to make this an issue of the fact that his hand or his fingers were not severed. It couldn't be a shear hazard. That is an oversimplification. Our expert testified that, well, it doesn't have to be a cutting action, meaning like scissors. What you've created is a potential for close proximity. This is volume 3, pages 96 to 97. On 97, he says, if you're saying that he did not shear his hand, evidence would demonstrate otherwise. Are you saying that means that no shear hazard existed? No, sir. It existed. It has been present, it has been cited, and it was never corrected. And past that, I stand by what we said a year before trial. This does not require expert testimony. And if it did, again, every case would require human factors and biomechanical engineer. These are decisions that a jury is capable of making based on their common sense, and would not be helpful to a jury to hear arguments day in and day out from purported experts about, how you interact with simple mechanics.
But if you don't have, I'm going to get back to the pull strap for a minute. If you don't have an expert talk about that, had the pull strap been used or had the pull strap been the correct length, you wouldn't have an injury. And if you don't have the plaintiff testify about knowing there was a pull strap or his reasons for why he didn't use a pull strap, doesn't it simply seem that what you're doing is you're asking the jury to look at a technical violation of the regulations on the length of the pull strap and somehow infer that that's what caused the injury in the absence of the evidence?
I think the evidence was clear based on the purpose of the code that these are very known and accepted hazards, what a shear hazard is, what an entrapment hazard is, and why a pull strap requires someone to use two hands and pull back and away to close that door to keep a person away from the door. And I think this is very similar, where we're not just relying on some sort of regulation to create this negligence per se argument. Like Los Compadres said, we must take it into account in the totality of the circumstances. But in analyzing this case, I think it's necessary to look at one of your sister courts, the Fort Worth Court of Appeals, when they, in Duncan First Texas Home, and I want to address this in my last few minutes because this was an open and obvious question, but addressed the subjective knowledge of the employee. So it was a non-subscriber case, and he walked down the stairs multiple times. I'm sure you're familiar with the case. And they could not say, as a matter of law, because this duty question is a matter of law, they could not say that that danger was open and obvious as a matter of law, because the hazard created by the insufficient clearance between the swing of the door and the edge of the platform was a violation of OSHA regulations and other building codes. And so here, when we're looking, have they conclusively proved, that is their burden, have they conclusively proved to you that there is no duty on these owners to correct known violations that the state of Texas has agreed they are unacceptable dangers? And so again, in defining this case, in analyzing duty, causation, and negligence, we must look to the correct hazard. And the hazard is the crush, the shear, and the entrapment hazards created by their knowing refusal to fix them. And as to the last question, the jury's refusal to find that Mr. Roberts was negligent in causing the incident, again, they were more than entitled, based on the evidence before them, to find that he would have used a pull strap hanging in front of his face. that it would have acted as it was intended to do. And more importantly, the question is really not about getting hung up on the pull strap, because the question is about whether it caused his injury. And we know that accidents happen. The Texas Supreme Court has told us that's accidents happen, and sometimes people aren't at fault, and the jury's not required to find that they're at fault. But the jury in this case was asked whether their negligence caused the injury. And again, that jury was capable of seeing what a 3/4 inch to 1 inch astragal, the space it would have created. His hand was like this. He demonstrated it for him on the stand. They were capable of determining that whether he was negligent in getting his hand caught in there, he was not negligent in causing his injury. And that was all on the part of those defendants who knowingly chose to tell the state they'd done what they hadn't done.
Was there any evidence in the record on why he did not use the pull strap?
Again, no, sir. He did not recall whether he used it. In deposition, there was more of a question where he was like, I don't know. And so at trial, the testimony really centered around, I guess he did it. I guess he used the handhold, because again, that's the more logical conclusion, is that when you're supposed to reach up and over 6.5 more inches, to use some strap, when there's a lip right here, that's what a person is more likely to do. And again, he couldn't get it moving with one hand, so that's when he reached up with the other, putting his body weight into it.
But my point was earlier, the issue of whether to use the pull strap or the decision to pull on this ledge, there's no evidence. I mean, and we're talking about what may be the most logical thing to do now, but there was not any evidence from a testifying witness that the strap was rejected because it was too short, or that somebody used the ledge because they didn't know what the strap was for, or anything like that. The jury was just asked to speculate about why the ledge was used, right?
No, Your Honor, I think they could see Mr. Roberts. They watched him every day at trial. They could see how tall he was. They saw tape measures against the door. And they're able to make a common sense determination of whether it's more likely for him to reach up 6.5 more inches when he didn't have that 6.5 more inches. And I think it's important to look at Del Lago versus Smith when we're talking about causation, because the jury said, or the court there says, there's all these moving factors. There's 20 to 40 men in a brawl, and the jury was capable of determining that a security presence at any point in there would have diffused it. And that's why we have juries. And again, they get it right. And I would just submit to you that the judge and the jury got it right this time.
Your
Thank
time
you.
is up. Are there further questions, Ms. Owens?
I don't think further.
Thank you.
Mr. Higgins?
Yes. The court is presented with the case that was tried, not the case that could have been tried. And the case that was tried, there is zero evidence that Mr. Roberts used that pull strap. There is no evidence that of any reason why he did not use the pull strap. And the pull strap is the only item that Mr. Roberts would have come into contact with before he placed his hand in that door. Now, the shearing hazard, there is no shearing hazard. The record is very clear on that. So we come to the astragal. The testimony was a 1/4 inch. It would have left maybe a 1/4 inch clearance between, or gap between, I wouldn't say gap, between the doors, but this pressure is still going to be coming down. There's no testimony about what that 1/4 inch would have done. There's no testimony about what force that 1/4 inch would have, what amount of force that 1/4 inch would have reduced. And without that evidence, there can be no finding that the injury was caused by the accident, or the injury by the absence of an astragal, or that the injury would have been less severe than if an astragal had been present.
In reviewing the record, I noticed that sometimes there was testimony about a crushing or shearing hazard in relation to the astragal, and then sometimes it was mentioned to the rigid member of the metal doors themselves. Was that important semantic at trial, or?
Candidly, Olson's testimony on that is a mess. There was testimony to rigid members. There was testimony in the astragal. I addressed the rigid member and the astragal separately, but I think what it comes back to is the rigid member is out of there because there's no shearing injury. And the astragal is all that is left. And there's no evidence that the astragal had any effect on the injury that Mr. Roberts had. Yes, the way to do it would have been to present a human factors expert or a biomechanics expert to explain how much how the force by the amount by which an astragal would have reduced the force on Mr. Roberts. That testimony was not presented. That testimony was not there.
Suppose I get on the elevator and I see the strap, and we'll say in this instance the strap's the correct length, but I don't know what the strap's for. I don't know how to get the door closed, so I use the ledge instead. In this case, all of that was presented to the jury, and the jury said that the plaintiff wasn't negligent in the way he did things. So I'm unclear about how that works in relation to this case.
How it works in relationship to this case is, number one, Mr. Roberts could not remember whether he used the strap or used the handle. Number two, there was no testimony from the plaintiff's liability expert, no human factors expert who said, there was no testimony that there should have been a warning that said use the pull strap. There's no testimony in this case to that effect, and the court needs to consider the case as it was tried in the record as it is. There's just no evidence on that point. And I think a third issue that is very clear to me is the plaintiffs rely on the purpose of, I guess, the safety measures that their expert identified to show causation. Well, causation and negligence are two separate points. And that may go to negligence, but it does not go to causation. And if you could use the purpose of safety measures to establish causation, then the Supreme Court's precedent, the Supreme Court's decisions, key cases, would have come out differently. In Southwest Key, there would have been proof of causation because, after all, a knee brace is designed to prevent a knee injury. In Apodaca, there would have been proof of causation because, after all, the industrial hygiene measures that the plaintiff asserted should have been taken.
If the open and obvious is a question of law, if the open and obvious is a question of law, how would we limit it so that if anybody, there's testimony, you stick your hand in the elevator, it's open and obvious, there's no claim. How would we limit it to this case so that there wouldn't be claims for this all over Texas?
Well, I believe the Supreme Court has told us that. The Supreme Court has told us that. There are two exceptions. There is the necessary use exception, where a property owner has a duty to take steps beyond a warning if there's a necessary use. That is not in this case. And then there's a criminal activity exception. And the Texas Supreme Court has not adopted any other exception. It's a duty to warn or make safe, and the duty can ordinarily, absent those two exceptions, be discharged by providing the warning. And I see my time is up. Unless there's any questions, I will sit down.
Thank you.
Thank you.
The case is submitted, and we want to thank counsel for traveling here to the law school so that the students could observe firsthand oral arguments, and we appreciate so much y'all being here today. And we also would like to thank the Texas Tech University School of Law and Dean Jack Nallen for hosting us today. And if there's nothing further, we'll be in recess.
All right.